There you are, Mr. Barr.
Good
Okay,
morning.
you ready to go?
Yes, Your Honor.
How about it?
Good morning. May it please the court. My name is Chad Barr, and I have the privilege of representing the appellants in this case, Malik and Shalimar Coleman. I'd like to reserve 5 minutes of my time for rebuttal.
Sure.
In this appeal, we are seeking a reversal of the trial court's final judgment in favor of Security First Insurance Company. While our initial brief did address two issues, one being the summary judgment, the other being the motion to dismiss, just so that we didn't waive any issues with respect to Tipsy Coachman. It appears based on the answer brief that the only issue that we really need to address is the summary judgment issue. So with that being the case, the issue for the court to decide is whether the appellants in this case were making a supplemental or reopened claim such that additional notice was required pursuant to 627.70132. If the court will indulge me, I think we kind of have to build this argument from the ground up. And in doing so, I'd like to take the court through a couple things: the statute, the arguments below in the summary judgment, the arguments at the hearing, and then the arguments on appeal. Because what I think you're going to see is that there's sufficient clarity with respect to the statute as to what this claim actually was. There's insufficient evidence as to what Security First says this claim is. And the arguments on appeal being made by Security First are substantially different than the argument that was made below at the trial court level. So with that being said, the statute that was in effect when the Colemans were issued their policy, in my opinion, was not entirely clear as to what exactly a supplemental or reopened claim was. In fact, the statute uses supplemental and reopened claim interchangeably with no difference in definition, even though I think in common sense, we know that those at a minimum are two different things. So based on that statute, we have really the only case that the appellee relies on, which is the Goldberg decision out of the Fourth DCA. And that case basically says that if there's a dispute between an insurance company and its insured with respect to the valuation of the claim, the insured has to provide notice of a supplemental claim. Now, I believe that case was wrongly decided, but I think the Florida legislature made clear that that case was wrongly decided the next year in 2021 when the legislature amended 627.7031. And what the legislature basically said was, hey, we need to clear up the statute in light of the Goldberg decision and make it clear what we were saying with respect to supplemental and reopened claims. So, and what we got was a definition of supplemental claim that's much more clear, and a definition for reopened claim, which is much more clear than the 2020 and prior version. And both of us agree that if there's some confusion with respect to what was in the 2018 version of the statute, this court can look to an amendment, especially an amendment that's issued right after a dispute with respect to that particular policy, which I would submit the Goldberg decision is a dispute with respect to the interpretation of that statute. So what we end up with is a definition of supplemental claim that says that is a claim for additional loss or damage from the same peril. So a supplemental claim is only a claim for additional loss or damage caused by the peril that the insurer had already adjusted. The amendment also provided a definition for a reopened claim, and a reopened claim is now defined as a claim that the insurer has previously closed, but that has been reopened upon an insurer's request for what? For additional cost for the loss or damage previously disclosed. So the loss ended up being more expensive than what the insureds had originally submitted that the loss would cost. So, and essentially in a reopened claim, the parties had agreed principally that, hey, this was the amount, we're not going to contest that. And they get into the work and they realize that it's more expensive. So we need to request additional benefits from the insurance company. That would, in my opinion, fall into what a reopened claim looks like. So in this 2021 clarification, seemingly in response to the Goldberg decision, it does two things. One, it makes clear that it does not apply to the scenario that we have in this case, where an insured merely disagrees with the insured's valuation of the claim. And it demonstrates why Goldberg was wrongly decided, because a supplemental claim, by definition, is not when an insured merely disagrees with the insurance company's valuation of the claim. Now, let's look at the summary judgment motion that defendant or the Security First relied on, and we have to consider it because that's what the court based its decision on. The motion for summary judgment states in the facts section, quote, the Colemans did not provide notice to Security First of a supplemental claim, this is important, for any new or additional damages from the Hurricane Michael claim. We agree with that. There was no claim made for additional damage. That would be a supplemental claim. Security First is agreeing with our definition of supplemental claim in their own motion for summary judgment. Security First then goes on to state in their motion for summary judgment that, quote, the Colemans did not request that Security First reopen their Hurricane Michael claim. This is true. No notice of a reopened claim was provided by the Colemans because there is no summary judgment evidence indicating that the Colemans were making a reopened claim as that term is defined in 627.70132. Now, moving into the meat of the summary judgment argument, Security First states that it is entitled to summary judgment. Why? Because, quote, prior to the filing of the current complaint, Security First was not put on notice of any new damage, nor was it asked to reopen the claim based on increased damages or new information or any other reason. So again, they're agreeing with our definition of supplemental and reopened claim under 627.70132. This argument tracks the 2021 amendment. It tracks our arguments in this appeal right now. As we get deeper into the meat of the argument section of the motion for summary judgment, we see that Security First provides a proposed definition of a reopened claim. This is very important. They say, quote, as apparent from the above cited definitions, a reopened claim is one that is reopened at the insured's request for additional cost for loss or damage previously disclosed. We agree with that definition, but there is no summary judgment evidence demonstrating that the Colemans were pursuing a reopened claim as defined in that statute.
Excuse me, Mr. Barr, excuse me. I don't want you to answer this right now because you may not know off the top of your head. If you do, fine. But at least when you get up for rebuttal, I'd like to know where in the record at the summary judgment hearing you made this particular argument.
This argument is merely, this is the argument that was made below. And I'm simply pointing out now that Security First was agreeing with our argument with respect to the interpretation of the statute.
What I basically recall about your argument in the trial court is you took the position that the statute of limitations is 5 years. We had 5 years to do this. And we had no obligation. We filed the lawsuit that put them on notice. It doesn't matter that we dismissed it. And we have 5 years.
So when we get to, and it's kind of leading into one of my next points, but when we get to looking at what they argued at the summary judgment motion hearing,
well, I'm more concerned with what you argued. What you argued below is what you're confined to arguing here because you are the appellant.
The only argument raised by Security First that we could respond to was that this was a reopened claim. That is the only argument that they made at the summary judgment hearing. So I may be misremembering the record, but I don't specifically recall you challenging that position. You may have, I don't recall it. That's why if you can point that out to me on rebuttal, don't take your time up now to do it. Understood. And I can always look later myself, but my recollection of your argument was we put them on notice when we filed that suit. It doesn't matter that we dismissed it. They closed it, but they didn't tell us they closed it. And we have 5 years because that's the statute of limitations. So I'm paraphrasing, but that is my recollection of the gist of your argument. I'll look back at it during Ms. McDonald's argument. So then we look at the summary judgment evidence that was filed, and the summary judgment evidence demonstrates absolutely nothing. They argued that they issued a policy, there was a claim, they adjusted the claim, and that we filed a lawsuit, that we dismissed the lawsuit, and that they received no additional notice of the claim. I think we look at the definition of supplemental claim in Ms. Erickson's affidavit. She says prior to October 10, 2021, the Colemans did not provide notice to Security First of a supplemental claim. For what? A supplemental claim for new or additional damage from the Hurricane Michael claim. So they never took the position below that this was a supplemental claim merely because we disagreed with the valuation of the claim. They took the position below that because we dismissed this case the first time, that the claim now becomes a reopened claim, but they never in their summary judgment evidence made it to where this fit within the definition of a reopened claim, that in their own motion for summary judgment, they agreed it needed to be new or additional damage from a claim that they had already adjusted. Moving to the actual summary judgment hearing, that's some important arguments made by Ms. McDonald at the summary judgment hearing. And one, I think, really brings it home, Judge Kelly, that their only argument at the summary judgment hearing was that this was a reopened claim. Ms. McDonald said, what's really important here is that the matter was closed when the plaintiff chose to file a voluntary dismissal. The policy language and statute are very clear. You have to give us notice within 3 years. She then goes on to say and agree that this is not a supplemental claim. She says they gave us notice of the initial claim. We adjusted the initial claim. We opened coverage and we made a payment. They disputed our decision on the file. So then they filed suit in 2020, which we didn't dispute. I didn't say that was premature, I don't think. I said, there was no problem with that. But then they chose to voluntarily dismiss that, which to me and under the law means, okay, we're backing away. It's voluntarily dismissed. That closes the claim. So based on that argument at the summary judgment hearing, Security First stipulated that the amount owed, the dispute with respect to the initial claim, is not a supplemental claim. So that only leaves us with the question of whether the facts of this case fit within the definition of a reopened claim, as that term is defined under the statute.
Well, I'm not sure. I think I'm missing your point. Is your point that you didn't have to give notice at all? That you just the 5-year statute limit and limitations applies, and you weren't required to give any kind of notice?
Primarily the point being that the trial court misinterpreted the statute. And
but what's your argument to us? What is your argument here? What is the error that you contend the trial court made?
The trial court misinterpreted the statute by requiring notice when the facts, there are no evidence. There's no evidence.
So your position here is we weren't required to provide any notice, not
Correct.
that you did.
The summary judgment evidence does not conclusively establish that we were required to provide notice of either a supplemental or reopened claim.
In the trial court, you argued you did provide notice, that your lawsuit was the notice.
We argued that if the court is looking at this through the purview of a supplemental claim, then the first lawsuit.
I don't recall you challenging that in the trial court. Again, I'm going to look at that carefully, but what my recollection is everybody took that as a given, and the argument was over whether you are.
That is what this case is about, whether we were required to provide notice.
Air Force Base. It's like an air show today. Your argument was that when we filed this lawsuit, that was the notice, so we complied.
Our argument was that with the first lawsuit, if we're looking at this strictly as a supplemental claim, then filing the first lawsuit that was ultimately dismissed satisfied the requirements.
Okay, I understand your argument. I'll have to go back and reread that.
And so just to kind of to bring the building of the argument full circle, what we have now is we have Security First arguing in this case for the first time. And again, this was not the trial court's conclusion because they didn't make this argument below. But for the first time, Security First is claiming that if an insured is not satisfied with the indemnity payment, if they contend that it is an inadequate or an underpayment, they have the burden of making a supplemental or reopened claim to the carrier, wherein they show the carrier what additional amounts they contend are due and owing in addition to those already paid. So this argument is already in direct conflict with the arguments that they made below, because they told us below what they thought a supplemental claim was. It was new or additional damages. They told us what a reopened claim was. It was new or additional damages. And so now they're saying, well, if you disagree at all, then it's a supplemental claim. And the statute simply does not support that. So at the end of the day, we've got a clarification that the court can consider of 627-7132 with definitions, clear definitions of a supplemental and reopened claim. And we've got no evidence that the insureds were making a supplemental or reopened claim. And I think too, if we look at this, we have to look at the net effect of all this, because this case is not just an isolated factual scenario. This is a case that's going to affect many other cases, especially in the state of Florida, where we have hurricanes quite regularly. And at the end of the day, the interpretation that you dispute the amount owed is a supplemental claim just doesn't make logical sense. So besides ignoring what the actual statute says, if we accept Security First's interpretation, it assumes, with respect to a reopen claim, it would assume that the insured, the policyholder, would know when Security First closed the claim.
Mr. Barr, you're into your 5-minute rebuttal time.
Okay.
Proceed as you wish.
And I just want to make one point about that, because you argued that in the trial court. That's a flaw in the statute. There's nothing that requires them to notify that they've closed a claim. So
the duty has to be
you
based
can
on.
point it out to me if you want, but I didn't see it.
Okay, I'll use the rest of my time for rebuttal. Thank you.
Okay, right. Okay. Ms. McDonald.
Thank you. Good afternoon. May it please the court. Tara McDonald on behalf of Security First Insurance Company. I think one thing that it's really important to start with here is counsel keeps referencing that there's no evidence before the trial court, but I'd like to point out that the only evidence before the trial court was that submitted by Security First. Contrary to the summary judgment rules, the counsel below did not file any response. There was nothing filed, and as the court knows, under the rules, there is a must in Rule 1.510C5, which says
aren't they entitled to argue that what you have submitted is not entitled you to summary judgment? Isn't the burden first on you, and then they don't have any burden if you have not met yours?
Absolutely, Your Honor, but they didn't do
So
that.
he's not. He's not relying on evidence that he didn't submit. Correct. He's relying on what happened below and what was in the record.
To a certain extent, yes, but they did
So
not ever contest in the
what
record.
possible construction of the rule would require someone to file evidence that they don't need to prevail?
I do agree with that, but Your Honor, what I think was important is that they didn't contest the facts and the timeline that we set forth in our motion. He says there's no evidence, but the evidence that was submitted clearly provided that there was no notice, no statutory or
But you know, that again is in a legal conclusion if they are correct, that if they are required to make a supplemental claim, that their lawsuit suffices a notice, correct?
Correct. And I'm going a little out of order here.
Let me ask you this. Is your practice to close the file solely on the basis of the voluntary dismissal of the lawsuit?
So, Your Honor, I think that if you look at what was argued in the motion, that can confuse the issue a little bit, because really, I think that whether or not the matter was closed then or closed twice really doesn't affect the issue here, which is that they were required to give a statutory and contractual notice, and they didn't do it. And that wasn't done at any point in time in the timeline, which I can go through with the court so that you can see the timeline of how everything happened and how they failed to comply. So the operative facts here that I think are really important, the issues as outlined are whether they were required to give notice, and then whether the filing of a lawsuit qualifies as notice. And I think it's kind of easy to get rid of the second issue. So I'll go out of order a little here to whether the filing of a lawsuit qualifies as giving notice. It's clear that you can't satisfy a condition precedent by doing the thing that it's supposed to proceed. You can't satisfy something that has to be done before you're allowed to bring a lawsuit by bringing a lawsuit. That doesn't make any sense. It's not the way it works. It's like in foreclosure, if the bank didn't file a notice of default, saying, well, we filed a lawsuit and then maybe that one was dismissed, so that satisfies the requirement. That's not how it works. Jumping to the first question is whether or not notice was required. I think in this, it's undisputed based on the facts that were presented to the trial court that yes, notice was required. And some of the quotes that opposing counsel mentioned were taken out of context, and I don't think were entirely quotes. If you look at the motion for summary judgment, it did lay all of these arguments out. We did argue in the summary judgment motion that notice was never given. It was just not maybe eloquently expressed in some of the arguments that I made before the trial court, but it's definitely all in the motion for summary judgment. So what facts are important here is that this is a Hurricane Michael claim. It's very important that it's a hurricane claim because as we know, the statute at that time required that it only applied to a hurricane. The facts also that were not disputed and not contested was that Security First opened the claim, they adjusted the claim, they issued a payment for the claim. Once they issued a payment for the claim, there was complete radio silence from the appellants. The payment was issued on January 29th, 2019, that's set forth in the affidavit. There was nothing, there was no indication at all, no communication that that amount was not sufficient. At that point, the claim, yes, was closed because they don't just sit open indefinitely. And obviously, if they filed a lawsuit, they also felt that the claim was closed at that point. So there was nothing at all that happened. Then they filed a lawsuit February 7th, 2020. We don't know why that lawsuit was dismissed, but the lawsuit was dismissed. Even at that point, it was dismissed on December 28th, 2020. That was still prior to the 3-year time frame for filing notice. There was still radio silence after the lawsuit was dismissed.
Lawsuit was dismissed, of course, without prejudice. Obviously.
Yes, absolutely, dismissed without prejudice. And in the argument below where I said that whether that was premature or not didn't matter, my point to that, and again, maybe not eloquently expressed, but the point was that lawsuit is over, it's done. Like I wasn't part of that lawsuit, and so there was nothing I can do about that lawsuit at this point. So the issues are being raised now because I wasn't part of that lawsuit. So that wasn't very eloquently expressed, but that's what I meant with those comments that he was quoting. So then after they did that, there again was nothing. And then October 10th, 2021, the 3-year deadline for filing a supplemental or reopen claim came and went. And then there was still nothing for quite some time until right before the 5-year statute of limitations when lawsuit number 2 was filed.
So, Ms. McDonald, under the terms of the policy and the statute, what is a claim that has been previously closed? And what that seems to be used as a term of art.
Well, Your Honor, first, the most important thing to bring up here is the previous version of the statute didn't actually use that terminology. Mm-hmm. I did quote the change in the statute because I do think it helps clarify the difference between a supplemental and a reopen claim. But the policy and the statute that was in effect at the time simply says it applies to any additional claim for recovery. The language is very broad, any additional claim for recovery. And the prior version of the statute did, and the policy did kind of lump supplemental and reopen together. Nowhere in my motion for summary judgment or in my brief did I ever say that it was one or the other. As a matter of fact, one of the things I pointed out in the motion for summary judgment is I'm not really sure whether they're bringing a supplemental or reopen claim because, for one thing, the lawsuit that was previously filed was in county court with a lower jurisdictional amount. The county court cases between...
Let me interrupt because I'm looking at the policy language. Mm-hmm. Actually, I thought I'm trying to find it. But does the policy language use the term reopened claim?
Yes, Your Honor, it uses it.
Okay, so let's go with that.
Yes.
What is a closed claim that would lead one to be reopened? So, is it simply paying? Is it simply we make a payment, it's closed? Is that the insurance company's position? Or is there a release that's required, which then leads to a closed claim? What happens?
So I think it's when everything that needs to be done is done, right? In this particular case, the claim was open, the claim was adjusted, payment was issued, no further communication was received. It's closed, it's done. There's nothing else. It's not like they contested it.
So your client's position is if we make payment, the claim is closed unless something happens later.
Yeah, exactly.
Is there a time frame when a claim becomes closed? Is it like we send a check, it's negotiated, that's what closes it? Is it we send a check, it's closed because we have sent the check, whether they negotiate it or not? Because the policy doesn't say that. The policy doesn't really address it. And the statute, whether the old or the new, doesn't really address what is a closed claim.
Exactly, but I don't think that it's necessary for there to be a definitive time. I think in some ways, a lot of common sense is required. When we have completed everything that we are supposed to do, we being Security First, as far as adjusting the claim, coming up with a coverage determination, issuing payment. And then if they don't tell us that there's an issue with that or a problem with that, then I do think the claim is closed. It's some of this can be common sense because the statute doesn't have a definition of, you know, when a claim is officially closed. I think you can use common sense and apply that to these to figure out, okay, we paid. They never contested the amount that was paid. They never said to Security First, that's not enough. They just went straight to a lawsuit. And because there is a specific statute that applies with windstorm cases, they can't do that. It's, you know, this statute requires, if you don't think we paid enough money, if you have any additional claim for recovery, that's what the language says, any additional claim for recovery, you have to let us know and give us the opportunity to fix that.
So
But
this-
what they're
this is
saying
a-
is this is the same claim. It's not an additional claim. This is the same claim and you didn't pay enough.
So remember though, the way the statute is phrased and the case law, if you do see, look at some of the case law interpreting it, it is related to whether you need more, like if you look at the definition, which I believe you can look at the definition in a subsequent statute to figure out what was needed, what was meant by the prior version. If you look at the definition of a reopened claim and a supplemental claim in the new statute, it makes it clear that what the legislature was trying to say was, if you are you're seeking a reopened claim, if you have a claim and you determine that you don't have enough money for it, we didn't pay you enough, we didn't cover enough, we didn't do enough, then you can come back with a reopened claim. Please reopen this claim, reevaluate, because we think you owe us more money. As a matter of fact, the Goldberg case even goes so far as to say you have to give us an estimate. There is a very recent case that came out called Patios, which disputes whether or not an estimate is required, but it still says notice is required, the new Patio case. And I'll get to that in a second. A supplemental claim is a little different. A supplemental claim is when you, because it's all the same claim. Remember, so what a supplemental claim, this definition says is you take off, for example, you take off the roof and suddenly you discover there's additional damage underneath that you didn't realize was there. That's the supplemental claim based on the definition in the statute. So the legislature has chosen for, or now it's for all claims, as you know, the statute has changed. But back then the legislature felt that for these hurricane claims, there is an extra requirement here that they are required to tell us if we haven't paid them enough money. And they've done that, I think, in part to try to decrease litigation because they have to tell us. Nowhere in the record did they ever tell Security First that they disputed the amount of money. They filed a lawsuit. And so essentially what their position is that they told us by filing a lawsuit. But again, as I stated before, you can't fulfill a condition precedent by doing the thing that it's supposed to proceed, which is the lawsuit. So I think that stretches the intent of the statute. And, you know, there is some case.
I mean, you know, the alternative is you pay a claim and then you have to wait 5 years and wonder if they're coming back.
Exactly.
I mean, I think that's the upshot of their position is, okay, even though you paid us, we're not going to say anything, and we've got 5 years to come back and ask for more, and we don't have to give you any notice, PS. And if they, you know, I mean, if the position is filing this lawsuit is notice, well, why isn't dismissing it like closing it?
Exactly. And, you know, one of the things with property claims is over time, it's harder to figure out what damage was associated with that date of loss. That's one of the reasons I think why these requirements are added. So 5 years later, how do you go back and figure out what damage was associated with that date of loss? I think, you know, again, that these statutes are all there for a purpose. They all have a reason for why we have them. And I think that saying that no notice is required ignores the existing case law. If you do look, and again, there's not a lot of case law out there, but if you look at the Patios case I was just mentioning, which is a new case that just came out very recently, even in that case, it's a case where it was below deductible. And the Patios court, Patios West 1 condominium versus American Coastal. That was just decided in January 3rd, 2024 in the 3rd DCA. That new case did conflict with Goldberg in saying whether or not an estimate was required. But even in that case, the court still found where it was a case that the insurance company found was below deductible, they still were required to give notice. It was just a question of what needed to be in that notice was the issue before that court. I think if you look at every case that has decided this issue, a lot of them were below deductible and were other things like that. They all say the same thing. Notice is required. It's just what notice is required. We don't have that issue here because no notice at all was given, except for a lawsuit. And I don't see how a lawsuit could possibly be construed as complying with a condition precedent, because that's the doing of the thing that's supposed to proceed.
So I have one other question, and again, it goes back to the policy language. And I know the statute has changed the timeframes, but the policy says you need to give us notice of a reopened claim within 3 years after the hurricane made landfall. Let's say the parties are going, and this is a hypothetical, but let's say the parties are going back and forth as to the value of the claim, and it doesn't get resolved for 2.5 years. And the homeowner is not really thrilled with it, but they're going to try and get it repaired and so forth. And then 3 years and 1 day after they realize you just haven't paid us enough. That can't qualify as a timely reopened claim, even if they do give you notice at that point, right? Because it has to be within 3 years of the hurricane. Under the statute, it's now 1 year. So if there's a lengthy period of back and forth, is there ever going to be a reopened claim after 1 year under the new statute?
So I think that's definitely going to be issues that are going to have to be resolved with the new statute. And the new statute applies to all claims, not just hurricane claims. And so I think that is something that's going to come up. But based on the terms of the statute, that's what it appears in the new version as well.
And I forgot there was a second question. Sorry about that. There is a definition in the policy of supplemental claim or reopened claim means any additional claim for recovery from us for a loss we previously adjusted. And I don't recall that there was an argument, maybe I just missed it or forgot about it. Was there an argument by you or by your client, either in the trial court or on appeal, that a reopened claim doesn't necessarily tie into a claim having been closed? It's simply a claim for a loss we previously adjusted.
So I think that that argument is in there because, again, we argued in here that we adjusted the claim and we issued the payment. So I think that argument is in there. I think
so a closed claim doesn't necessarily mean closing the book. Here's a letter saying we are closing the claim. We have adjusted it. You haven't disputed the adjustment for some period of time. We're done. That's your client's position.
And the contract that's what the statute and the contract says.
Okay, thank you.
Any more questions? Does the panel have any more questions about whether or not the filing of a lawsuit qualifies as satisfaction of the condition precedent? I can go into that a little bit more, but to be quite frank, I just see that argument as being quite a stretch. And so I can answer more questions about it if anyone has any.
Does it look like we have any more questions about it?
So based on the record before the court, it's our position that the summary judgment entered in Security First favor was correct and should be upheld on appeal. There is no evidence in the record that a supplemental or reopened claim was ever properly submitted to Security First prior to October 10th, 2021. I think that's well established. It's also our position that one was required, that if they disputed the amount of our payment and the amount of our disputed our coverage determination, they were required by both the statute and the contract to let us know that and to give us an opportunity, and they did not. And for those reasons, we think that the order should be upheld on appeal.
Thank you, Ms. McDonald. Mr. Barr, you have your rebuttal.
So much to do, so little time to do it in. But there's quite a few things that I want to address. Judge Kelly, the one thing I wanted to say with respect to the hearing transcript, the argument was not made below by Security First that disputing the amount of benefits paid for an initial claim is a supplemental claim. And in fact, they said the opposite. There would have really been no reason for there to be an argument with respect to whether notice was required with respect to a supplemental claim, because at the end of the day, I read you what they said in their motion, and it said new or additional damage. The policy, the statute says what it said. The argument was never made that they're entitled to summary judgment because this was a supplemental claim and we were required to provide notice. I have to address it all because they're both lumped together in the same statute without any distinction in the statute. So that's really the argument that's being made. The argument was made below that filing the lawsuit was notice of the supplemental or reopened claim. So the argument is well throughout the transcript. And so it's there. I just don't think, having been an appellate attorney for 15 years, and you folks have been doing this a lot longer than I have, but I don't see how the appellee can make an argument below one way, the court granted summary judgment, and then on appeal make a completely different argument, which now they're saying, well, if you dispute the amount we initially paid, now it's a supplemental claim. And if we close it whenever we want to close it, and we don't tell you we closed it, now you have to, file additional notice. It just doesn't work. Judge Kelly also wanted to address your statute of limitations and the statement that was made about stringing this along. This statute only would affect the statute of limitations on the initial claim. It wouldn't affect the 5-year statute of limitations on a supplemental claim, because if a supplemental claim is made within that time period as a true supplemental claim or a true reopen claim, you still get 5 years. So if we want to use the verbiage of stringing it along, if I make the supplemental claim on day 365, the breach, I still get 5 years to file that lawsuit. And so, or whatever the breach of contract statute of limitations is. This is saying I must provide notice within 3 years. It only affects the initial claim, whereas if I have 5 years to file suit, I have to give them notice within 3 years that I disagree with the payment. And that's not what the statute says. The statute says for new and additional damage. We look at the 2021 amendment to the statute. Difficult to determine damages. That was the comment that Ms. McDonald stated. That's why they do an investigation. They send adjusters out there. They take pictures. They do estimates. They draw everything up. If I come back and say, well, now I got in the attic and now I've got beams that I got to replace, that's probably a supplemental claim because that's new and additional damage that I didn't.
Let me ask you a question. We've had all this discussion about what kind of supplemental reopen, and I don't recall. I recall looking through the record. I saw the order or the notice dismissing the complaint that you all had filed that you then voluntarily dismissed. I never saw the complaint, and I didn't see anything in the record to tell me what the complaint was. What, were you asking for more damage? I mean, how would I even know, looking at this record, what you were claiming?
Well, my gut response to that is it's not my burden to disprove something that they haven't proven. They have to prove that it is a supplemental claim.
Well, you're arguing that it's not.
Well, I'm arguing that they didn't submit any evidence demonstrating that it's a supplemental claim initially. But if we go to Ms. McDonald's, her argument at the summary judgment hearing, she said they filed a lawsuit because they disputed the amount that was paid. She said that at the summary judgment hearing. So it was never a question of what the first lawsuit was for. Everyone was aware the first lawsuit was because the Colemans disputed the amount that was paid for the roof claim. This is a roof and interior damage. It's not a catastrophic, house blown down. I hate to use run of the mill because they may be watching and this really affects them, but it's in our world.
Let me just understand, they accepted payment, right? They accepted payment. And then the next thing was a couple of years later, they filed a lawsuit saying we weren't paid enough. Would that be a fair statement?
Correct.
Okay.
And there's no evidence that additional damage was being reported or claimed.
Okay, you're right at the end of your time, Mr. Barr.
I appreciate your time today. I hope you have a wonderful rest of your week, and we ask you to reverse.
Same to you. In order to leave our virtual courtroom, you should click the leave button. In fact, you must click the leave button in the lower right-hand corner of your Zoom screen, and you will disappear from our site, but not our thoughts.
Thank you.
Thank you very much, Your Honors. Have a
Thank
good
you,
night.
Governor. There you go. And that is our last case on the docket today. So we are adjourned. And we will click the leave button.